Hi friend, welcome to the company law update. Today we are discussing Calcutta High Court decision in the matter of the Satya Narayan Bank versus Union of India dated 11th February 2022. In this case, Calcutta High Court held that deactivation of the dean of the director is not automatic. In this case, writ petitioner are aggrieved by the cessation of office as director of one Mr. Henneman International Private Limited. The disqualification happened by operation of section 164 subsection 2 for not filing balance sheet and the profit and loss account for a continuous period of the 3 years from the year 2014-15. The ROC has also deactivated dean of the petitioner for which the petitioner are aggrieved. The petitioner have advanced threefold argument challenging such disqualification. First, they were not permitted to avail the benefit of the company phase start scheme of the 2022, despite applying this for the availing this scheme. And second, petitioner were not afforded a prior hearing before the disqualification as director and hence denied principle of the natural justice. And third, ROC is not authorized to deactivate dean of, and such activation of the dean pursuant to the disqualification is not automatic. Let's discuss the grounds of this judgment. On the power of the ROC to deactivate the dean of the petitioner, it would be necessary to go through the proviso of two sections, subsection 2 of section 164 and subsection 1 of section 167, introduced subsequently by amendment. Citing reference of the Karnataka High Court decision, Yasodhara decision, in this case, considerable force on the argument petitioner counsel as on 1st November 2016, when the petitioner were disqualified while they had to vacate the office of director, it necessarily referred to the defaulting company under subsection 2 of section 164 of the Act. But realizing the fact that if all the director in the defaulting company had to vacate office, then such board of the director would be bereft of the director and lead to absurd situation. The proviso was inserted to the effect that a director of the defaulting company shall not vacate office of the director in defaulting company. Therefore, said portion of the proviso could be constitute to be clarificatory in nature and therefore would have a retrospective effect. Further, while saying so, the proviso also states that director of a defaulting company could vacate office of the director in all other companies in which he is director. The same was not envisaged under section 167 subsection 1A of the Act prior to insertion of the proviso. But by the insertion of the proviso, such an immediate consequence is also envisaged. It has also been held above that such consequence cannot be held to be arbitrarily or in violation of Article 14 and Article 19, sub-Article 1 of the Constitution. But the proviso having come into force from 7th May 2018 cannot have a retrospective operation. So as to affect the petitioner who were disqualified on 1st November 2016, that is prior to the insertion of the proviso, that is 7th May 2018. The proviso to section 167 subsection 1A of the Act is not altered by Article 14 and Article 19 1G of the Constitution of India. The words provided that where he incurs disqualification under subsection 2 of the section 164, the office of the director shall become vacant other than the company which is in default under that subsection. Being clarificatory in nature, has retrospective operation, while the words in all the companies being introduced for the first time by way of the proviso pursuant to the Amendment Act 2017 has prospective operation, and the proviso would apply only to those directors who sustain a disqualification pursuant to 7th May 2018, that is the effective date. While saying so, the doctrine of the severability as applicable to interpretation of the statute is applied. Under the proviso to section 167 subsection 1, director of defaulting company continues to hold the office of the director despite disqualification. His dean cannot be cancelled. On the issue of the cancellation of the dean, reference was made to the company's appointment and disqualification of directors rule 2014. Under rule 14, consequences of the disqualification of the director under section 164 subsection 2 of the are mentioned, that every director shall inform to the company concerned about his disqualification. Under section 164 subsection 2, inform DIR 8 before he is appointed or reappointed. Further, whenever a company fails to file the financial statement, annual returns, or fails to repay deposit, interest, dividend, or fails to redeem debenture, as specified under section 164 subsection 2, the company shall immediately file Form DIR 9 to Registrar of Company, furnishing therein the names and addresses of all the directors of the company during the relevant financial year. That cancellation or surrender or deactivation of deed is stipulated in Rule 11 of the company's appointment and disqualification rules. It is contended that Rule 11 does not permit cancellation or deactivation of the director activity number on account of disqualification of director under section 164 subsection 2. That deed could be cancelled on the account of the death of director being declared as a person of unsound mind by a competent court, or being adjudicated as insolvent or for other reason, but not for suffering a disqualification under section 164 subsection 2 of the Act. Deed cannot be cancelled on the account of disqualification sustained under section 164 subsection 2. But at the same time, company must comply with filing Form DIR 9 to Registrar of the Company. It is therefore held that deactivation of the director identification number of the petitioner is not automatic. In view of the above, the deed of the petitioner shall be revived subject to the company having filed DIR 9 within the prescribed or extended time. The said deed shall not be applied to entitle the petitioner to act as a director in any other company. This is held by the Calcutta High Court. In case, if you want to refer full judgment copy, you may refer a link given in the description box. Thank you so much for watching this update.